Hello. Welcome to a podcast on the law and its impact on computing technology and business. This is Brian Gaff. I'm a senior member of the IEEE and partner at the McDermott, Will & Emery law firm in Boston. The IEEE is presenting this podcast in conjunction with my column that appears each month in Computer Magazine, a publication of the IEEE's Computer Society. That column discusses legal issues relevant to people in the computer hardware, software, networking, and service businesses. In the last podcast, I discussed intellectual property, or IP, issues related to three-dimensional printing. In this podcast, I'll cover some IP topics that startup companies should consider, which is the topic of my January 2015 column in Computer Magazine. During the excitement and chaos of starting a company, it's possible that some important issues might get overlooked. IP issues shouldn't be among those that are overlooked. Many IP issues have a tendency to lie dormant and spring to life at inopportune moments, like the day before you're about to launch the startup's new product. That can potentially prevent the launch or require a significant sacrifice, such as an expensive royalty, to allow you to proceed as planned. To avoid difficulty, it's best to attend to IP matters early on so there's enough time to uncover, confront, and remedy potential problems. A startup's most significant asset is typically its technology. So two IP areas should get early attention because they affect the startup's ability to sell its technology and the startup's ability to protect its technology. The first area is usually called freedom to operate. Just like it sounds, this relates to the startup's ability to sell its technology. It's an unpleasant surprise when you discover that something you've just developed might be covered by someone else's patent. To avoid infringement, you might need to re-engineer your product, and that might delay getting to market. To avoid this predicament, early in your design phase you should consult with a patent attorney who can help you search for patents that could block your product. If your design changes over time, you should repeat the search to encompass the changes. The central question is, then, what do you do if you find blocking patents? There are a few alternatives. First, you could try to license or buy the patents, but that might not be possible or affordable in all cases. You could ask your lawyer to do a legal analysis of the patents to determine if there's a possibility that they could be ruled invalid. This analysis is called an opinion, and it might be presented as a formal written report. Remember, in the U.S., patents are presumed valid, so the opinion represents the lawyer's legal analysis and conclusion whether there might be compelling arguments that could be made in court or in the patent office to get a ruling that the patents are invalid. Depending on the strength of those arguments, you might proceed notwithstanding the patents and rely on the opinion as a defense if you're accused of infringement at some future point. Another alternative is to design around the blocking patents. This means identifying the specific parts of your technology that the patents might cover and changing those parts to what's called avoid the patents. This might not be a simple exercise. You'll need to have your attorney carefully analyze the patent claims and interpret them using various legal criteria to determine what the claims actually cover. This will define the boundaries of the claims, and you'll need to get your technology outside of those boundaries. One reason why this isn't simple is that under U.S. patent law, the boundaries are not sharp. For example, the so-called doctrine of equivalence gives patent owners a little leeway on the scope of their claims. Your lawyer will help you identify those changes that are significant enough so as to avoid getting snared under the doctrine of equivalence. The other IP area of concern relates to protecting the startup's technology. This typically means ensuring that you've applied for patents in all of the countries in which you plan to market your product. Although this can be expensive, it's usually the best way to prevent others from duplicating your technology and setting themselves up as competitors. Keep in mind that you need to start applying for your patents as soon as possible. Many countries, including the U.S. in the last few years, have a first-to-file patent system. This means, for example, that if two independent parties come up with the same invention, the one who files his or her patent application first will be eligible for a patent, and the second to file won't be eligible. That means don't delay. Get one or more applications on file as soon as you can. This is especially important in those countries where, to maintain eligibility for a patent, you must have an application on file before any public disclosure of your technology. This is called having a requirement for, quote, absolute novelty, unquote. The U.S., however, doesn't follow that rule. In fact, in the U.S., inventors have 1 year to apply for a patent after any public disclosure. I focused here on patent issues, but there's a similar discussion relating to other forms of IP like trademarks. You should ensure that your company and product names don't infringe another's trademark, and you should take steps to protect those names and prevent others, like potential competitors, from using them. Your lawyer can help you navigate the trademark issue. Indeed, trademark issues can be complicated, particularly when names that are similar to your company name or product name are registered in the U.S. Patent and Trademark Office. By registered, I mean that owners of those names have applied for and received protection from the U.S. government to ensure that others don't misuse their names. There is a potential for trademark infringement allegations when your company name or your product name is confusingly similar to a registered trademark. What qualifies as confusingly similar varies from case to case. That's why for trademark issues, it's important to have a trademark professional guide you through the process of searching for similar marks and applying for trademark protection for your company name in your company product. I hope that you found this podcast helpful. Stay tuned for next month's column in Computer Magazine. Until next time, this is Brian Gaff. Feel free to contact me via email at bgaff@mwe.com. Thank you.